InFi, Episode 9.
Welcome to InFi, the Future of Finance, hosted by American economist and author Dr. Robert Murphy. Each week, tune in for dynamic discussions with business pioneers about emerging trends in finance, life insurance, asset management, technology, and more. Now, let's talk the future of finance.
Hey, everybody. Welcome back to the InFi podcast. Today, I'm going to be speaking with David Schizer, who is Dean Emeritus and Harvey R. Millow Professor of Law and Economics at Columbia Law School, an expert on tax law and policy, as well as nonprofits and energy. He is the author of How to Save the World in 6 Not-So-Easy Steps, Bringing Out the Best in Nonprofits, which is put out by Post Hill in 2023. David was a graduate of Yale College and Yale Law School, and he began his career as a law clerk to Associate Justice Ruth Bader Ginsburg on the U.S. Supreme Court and to Judge Alex Kozinski on the U.S. Court of Appeals for the Ninth Circuit. So what we're going to be talking about was actually prompted by, I have an economist colleague at Columbia who had mentioned that there was a pending Supreme Court case that, depending on how the court ruled, might have huge implications on the U.S. tax code and specifically on the treatment of what's called unrealized capital gains. And this has a lot to do with strategies that we here at Infineo employ. And so it's going to be very relevant to all of you folks listening at home, what we're going to be talking about. And so that's kind of the backdrop. And I asked my economist colleague, hey, do you want to come on the show? And he said, no, actually get my colleague David Schizer on, because not only does he know the finance and the economics, but he knows the law a lot better, as his bio that I just read to you certainly underscores. So very pleased to have this discussion. We were grateful for David's time. Here is a very informative conversation. I hope you all will enjoy it with David Schizer. David, welcome to the InFi podcast.
Great to be here.
Well, I'm very excited about this discussion. I think you're the most distinguished academic we've had on the show. Let me just, for the folks at home, understand, we don't even necessarily need to dive into this per se right off the bat, but to explain the context. So I am friends with an economist at Columbia, and he had a tweet where he was saying there's a Supreme Court case that may change the U.S. income tax as we know it. It reminded me about the 83 Stiglitz paper that show that you can avoid all capital and wage taxes if capital markets are perfect. The main problem, it's illegal under current law, but perhaps no more. And so he's alluding to this pending Supreme Court decision. So I'll do a quick read. He has an excerpt from this Stiglitz, and Stiglitz is a big economist, in case some of our listeners don't know that. I'll read that, and then David, I'll let you comment and just explain what the situation is. So this is from that 83 paper. The analysis of the effects of capital gains taxation requires a careful modeling both of the details of the tax code and the imperfections in the capital market. Under the standard assumptions concerning perfect capital markets, there are several strategies by which rational investors can avoid not only all taxes on their capital income, but also all taxes on their wage income. These strategies leave individuals' consumption and bequests in each state of nature and each date unchanged from what they would have been in the absence of taxes. And Okay, so that's kind of the baseline. So going from academic jargon and professional economist stuff to the real world, David, can you just explain kind of the general principle what we're talking about, and then what's going on in the Supreme Court case, and why that would lead my colleague to say, wow, this Supreme Court decision might really have serious implications about the tax code?
Absolutely. So the truth is, taxes are not supposed to be voluntary, but some taxes turn out to be voluntary. So if I work in my job and I earn a salary there, the tax is going to get withheld. It's going to get taxed. And in a system that was pretty clumsy, I might be able to come up with some tax deductions that don't really reflect the real economic loss and could shelter that income. And people used to do that 30 years ago, but Congress has responded with various limits. So I do think wages are taxed, and this case doesn't change that. But what's much more difficult for the government to tax is income from investments. And here we have a system currently that is voluntary in a way. If I buy stock for $1 and it's worth $100 2 years later, I'm $99 wealthier, but the Congress doesn't get the tax for me until I sell. And that's called the realization rule, which means you don't pay tax until you realize, until you sell. And that rule creates lots of possibilities for planning. and we can talk a bit about it. The Supreme Court is being asked to confirm or to say that the realization rule is not just something Congress chooses to do, but it's something Congress is required to do under the Constitution. And this Congress has a lot of rules now that aren't consistent with realization. They do tax before a sale to avoid the kind of planning that I was just referring to. And if the court says, no, you can't do that, then tax planning is going to become easier than it even is today.
Okay, so let me just try to repeat back what you just said. There's a lot of more maneuverability, like a tax on standard wage income. There's deductions and things, and maybe you can push the envelope depending on what tricks your CPA knows. But in general, it's hard to get around the fact that, no, your employer this year paid you this much in wages, and this is what the tax is, and there's FICA and blah, blah, blah. But in contrast, if you make your income largely, or to the extent that you earn income through a capital gain, then the baseline is that right now that's only taxed once you sell and realize the capital gain. So another way of saying is unrealized capital gains, even though on your books you can show it, technically that's the tax doesn't apply until the moment you sell. And then because of that, that opens up all sorts of opportunities. And I know, for example, I just empirically, like economists look at the effect of the tax code, and that, that Ronald Reagan in the 1980s, they lowered the capital gains tax rate. And then all of a sudden a bunch of revenue flowed in because people who had been holding assets in which they gained, once the rate came down, then they went ahead and realized it to be able to pay, and take care of that. And so, they was like, had to go with the Laffer curve and stuff. People say, see, they lowered the rate and the amount of revenue went up, on the capital part, not necessarily other stuff. So that's the big picture. And then you're saying that this now is a court case, and we'll probably want to get into the details in a second. But the issue before the court, amongst other things, could decide as if Congress did try to tax unrealized capital gains, that might be deemed unconstitutional to do that?
Exactly right.
Okay.
So why don't we spend a minute talking about the kind of planning that we should do under the realization rule? So Bob, congratulations. You founded a tech company. It's really amazing success. And you have stock worth $200 million, but you have a zero basis in it, or pretty close, because you didn't buy this as much as you started the company and put a bit of money into it. So the first thing that'll come to mind is, well, I'd like to spend some money. And what the government would love for you to do is to sell some stock to fund that consumption. And if you sell the stock, you'll pay tax. But you don't have to do it that way. You can approach bank and say, hey, listen, I'd like to borrow some money. And given your credit, you can even pledge the stock. They'll say, sure, Bob, how much do you want? And so you can live the lifestyle that you want to live without selling the stock. And then let's say you've got heirs who will someday inherit this property. Your goal should be not to sell before you die, because there's a second rule we haven't talked about, which is called the step up in basis rule. Mm-hmm. And that means that when someone inherits stock, say your $100 million, $200 million worth of stock, their basis will become $200 million as soon as they get the stock from you. The fact that you had a zero basis doesn't matter, doesn't affect them. And this means basically that the gain on your stock will never be taxed. So people talk about, hold, borrow, and die as a strategy. I'll add one other thing. Maybe you think that you'd like to be a bit more diversified, and just having all of your wealth in this one company, maybe it's not what you want to do. Again, you could sell to diversify, but if you approach the right tax advisor, they'll say, hey, no, Bob, you don't have to do that. We can help you hedge. We can get you a put option to protect you from risk of loss. We can have you sell call options, so you're giving up opportunity for gain. And as long as you keep enough of it, and we can talk about what enough means, but as long as you keep enough exposure, there won't be a sale. And one way to think about it is, if the stock is 100 and you remain exposed between the stock price of 95 and 115, you won't have a sale, but your risk of loss is capped. You won't lose more than $5 per share, and your opportunity for gain changes. So anyway, that's the planning. There are ways Congress has responded. There are ways Congress might someday respond, including things President Biden has proposed. But this Supreme Court case could make those responses impossible.
Okay, this is fascinating stuff. And let me I'm going to kind of repeat what you just said in different words because folks listening, as you know, at Infineo here, a big part of what we do is customize permanent life insurance policies for cash management purposes besides just the death benefit. And one of the advantages is, oh yes, you're building up this asset, the cash value, that if you handle it properly, there's no tax liability from the buildup. And then, if your daughter's getting married, you want to buy a new car, whatever, you just take out a policy loan where the company, the carrier, loans you money with the cash surrender value as the collateral. So that's not income, it's a loan, But if you run up money on your credit card, that's not taxed as if your boss gave you a bonus. And so, so that's the idea. And then eventually when you die, the death benefit passes income tax free to your named beneficiaries. So it's one sort of example. It sounds like you're saying there's a more general principle of what you can do. Can you speak, David, just real briefly? I think a lot of the listeners who aren't familiar with this stuff might have been following you like, okay, I could see if you bought stock at 10 and it went to 20, but you didn't sell it yet, that technically they couldn't tax you on it. And then if you're borrowing, you're pledging that as collateral and getting bank loans and you're funding your lifestyle, okay. But surely, I think they would have thought, once you pass it on to somebody has to pay the piper. How can you pass it on? And then the next person, your kid who inherits it when it was valued at 20, from their point of view, well, no, I got it at 20, so I shouldn't be taxed on a gain that I didn't enjoy. And so is that the idea that the argument is that, well, your kid didn't buy it at 10, so he shouldn't have to pay the tax. And then you didn't sell it, you just handed it over to somebody. Why would you be taxed on handing an asset to somebody? Is that kind of the idea?
So a lot of what happens in the tax law is about making the system easier to administer.
Okay.
And so really what happened is, it's fairly common, Bob, you might give appreciated stock as a gift to someone while you're alive. And the rule there actually is that they do get your basis. So if you pay 10 and it's worth 100 now, and give it to me, and thank you for thinking of me, Bob.
Well, I did. Thank you for being on the show. Yeah.
Right. Then my basis would be 10. My basis would be the same as yours. And if I sell it, I would pay the tax that you would have paid. So when it comes to gifts while we're alive, it's called carryover basis. And the tax liability doesn't go away, but it's delayed. If I don't sell, I don't pay the tax. If I give it to someone else and don't sell, they don't pay the tax. But it's different for inheritances. With an inheritance, if somebody leaves an asset to an heir, the old basis just evaporates, it goes away, and the recipient's basis is the fair market value. And I think the reason for this is intuitive in a way. So if I get a gift from you and I decide I want to sell it, well, I need to know what the basis was. And if it's a gift you gave me while you're alive, I can ask you. But if you've died, then barring some supernatural powers, I can no longer ask you. And I think 100 years ago, Congress decided it's not fair to make heirs try to figure out what the basis was of the person who died. And they were focused on the administrability and not so much on the fact that it would leave a hole in the tax base.
Okay. All right. That makes a lot of sense. Okay, great. Okay. So given that, what do you think, David, is now a good time to go into the particulars of the Moore case?
Sure. So I think there's the issue that's looming in the background, and then there's the real issue in the case. So maybe we can go through those because they're separate.
Sure.
So President Biden has proposed in each of the last two budgets to tax unrealized gains for people with the net worth of $100 million or more. So what that means is if a tech billionaire has a lot of appreciated stock, built-in gain, it's quite large. As we said, currently that person doesn't have to pay tax. They can borrow, they can hold the stock, they can even hedge the stock, and they can pass it on and it'll never get taxed. And under this provision, if Congress passed it, they didn't, but if at some point they did, then there would be an immediate tax on the built-in appreciation. So you have stock worth $200 million, you pay a $200 million tax. And President Biden proposed to spread the payments out because there's a recognition that there are liquidity issues and so on. And so that's, now, to my mind, that's still an income tax, not a wealth tax, because what the system is doing is measuring how much your wealth has increased. And traditionally, we measure that with a sale, but it doesn't mean you have to measure it with a sale. And there are ways in which the system already does things like what I just described. Another part of this conversation is that Bernie Sanders, Elizabeth Warren, others have proposed a wealth tax. And a wealth tax would be not just, hey, how much gain does Bob have in his stock? Let's tax that once. But just how much wealth does Bob have? We're going to tax that every year. And you could think of an income tax as a tax on getting rich, and a wealth tax is a tax on being rich. Now, we don't have a wealth tax in the US. I think it's probably unconstitutional to have a wealth tax in the US. But since it hasn't been tried, there at least hasn't been tried lately, that's just theoretical.
Can I ask you, David, just real fast? So one thing is, and I know some economists argue about this, but to me, a capital gain is income, like economically speaking. Like I don't care about the tax code, just saying like if I'm thinking about a theoretical economy, when you pin down what do you mean by income, it's like one definition is it's the amount of consumption you can enjoy over a given time period without lowering your wealth. And so if that's your definition, then obviously a capital gain in which your assets increase in value, you could consume that down back to your starting point. And that that would have to mean a capital gain is income. And then you're saying you don't tax. Well, is a property tax a tax on wealth in a sense, like a subset of your wealth? Okay.
Correct. And the states have property taxes. And the federal government cannot constitutionally impose a real estate tax unless it follows a kind of a challenging mechanism called apportionment. And basically what apportionment means is that the amount of tax that they collect from people in a state has to be the same percentage as that state's population in the country. So the idea is if Massachusetts and West Virginia have the same population, and let's say, and it isn't true, but let's say that it's 1/50th of the US, then each state citizen should pay 1/50th of the tax. Now, that's not a big deal if the property values in West Virginia and Massachusetts are the same, because then you could have the same tax rate. But let's say it turns out that the property values in West Virginia are half the level of the property taxes in Massachusetts, because Massachusetts is a wealthier state, and I think it actually is the second wealthiest state in the country. So if that's true, then the tax rate in Massachusetts would be half of the tax rate in West Virginia. Under this idea of apportionment, if each state has to give its share, and the share is based not on how wealthy the state is, but on how many people it has, then you have the ironic effect that the poorer the state, the higher the tax rate. And this is not something that particularly appeals to members of Congress. So although in theory, they can impose a federal property tax, they'd have to do it with this apportionment. And so they generally aren't going to do that.
And that's coming from a specific clause in the Constitution, right?
Yeah. So, but look, if you remember your history, what was the American Revolution about? It was about no taxation without representation. It was a tax revolt.
Right.
So the first government that we had was called the Articles of Confederation, and they wanted to be really careful not to repeat the mistakes of King George. And so there wasn't going to be a mandatory tax coming from a faraway capital. So they actually made the taxes voluntary at the federal level. They said to each state, this is your share, please pay. And Bob, would you be shocked to know that when taxes are voluntary, people don't pay them? So the Articles of Confederation failed mostly because the federal government had no money. The Constitutional Convention comes in, and they're basically trying to balance two things. And the first thing is, look, we really we have to have representation if we're going to tax. And then the second is, but we have to do better than the Articles. So there have to be mandatory taxes. And the bargain that they struck was to say that most of the revenue was going to come from tariffs, import duties, excises, which is stuff made in the United States, and consumption taxes. And for those, Congress has the power to do it. And the only limit is it has to be uniform. So if they're going to tax the import of paper in Virginia, it has to be the same rate as the tax on the imported paper in Massachusetts, Rhode Island, Georgia. So uniformity. But then they have this other thing called a direct tax, which I think is really, it's essentially a wealth tax. And for those, they have to be apportioned. And that's what we were talking about a minute ago. And it wasn't clear what an income tax was. Congress created an income tax during the Civil War. It was upheld. But then in the 1890s, they created a different income tax and the Supreme Court struck it down. And so the Constitution was amended to say you could have an income tax without apportionment. And so that's why we've had an income tax since 1913, but not a wealth tax because the amendment didn't allow a wealth tax.
Okay. 1913 was also the founding of the Federal Reserve. So a lot of people I know on the right do not like the year 1913. Okay. So thank you for that. And then is the reason, I'm just curious, is the reason the consumption tax was okay in their mind was that in a sense that was voluntary too? Like you could just choose not to drink the tea or whatever?
That is exactly what they said. They said it's less burdensome because people can choose how much they want to buy. Wealthy people are going to buy more. So it's even achieving this distributional goal. And the other thing they said is, and it's a Laffer curve point, and it's impressive that you see the Laffer curve discussed in the Federalist Papers in the 1780s. But they basically said, and there's a built-in limit on what the government can charge. Because if the rate gets too high, they won't get any revenue because people will just stop buying. Right. The framers were much more comfortable with that and much more nervous about property taxes because you can't really avoid them. That's why they call them direct taxes in the Constitution. Right. If I'm alive and I own something, they can tax me and there's nothing I can do about it. And there were some people who didn't want to include those taxes, but people like Alexander Hamilton said, no, we should include it. We should just make it subject to this apportionment requirement. And the main thing they were thinking about is wars. Because back then, if you were only taxing imports, well, we didn't have much of a navy. And during a war, there weren't going to be imports. So the government wasn't going to have any money.
Okay, great. All right, so that was a very interesting historical detour just to remind us of stuff that I think many of us like, oh yeah, I kind of remember that from 30 years ago. Should we talk about the Moore case specifically at this point? Okay.
Yeah, absolutely. So the taxpayers joined a friend and some other people in starting a business in India, which makes machine tools of various kinds. And they owned about 11% of the company, which means these are U.S. citizens, U.S. taxpayers who own a foreign corporation. And there's a special set of rules which address foreign companies doing business overseas and when, if ever, the U.S. is going to tax that. And the general rule used to be that if a company is an active business, so not, by putting money in a bank account and earning interest, with that kind of passive income, the U.S. shareholder is taxed right away. But otherwise, with active business income, selling things, doing things, the income is not taxed by the United States, or at least it wasn't until it was paid as a dividend to the shareholders. And remember, the fact that a company is an Indian company doing business in India means it's not in the U.S. tax jurisdiction. The U.S. can't tax everyone in the world. They just have to, they can only tax either American citizens, American companies, or work that has a connection to the U.S. And this didn't. So the company was earning money, and therefore the value of these shares presumably was increasing, but they weren't paying tax because they weren't getting a dividend. Now, this was just a small little example of a much larger phenomenon. U.S. multinationals generally were keeping their foreign earnings overseas and not bringing them back to trigger U.S. tax. And so in response, Congress changed the system in 2017.
Can I stop you, David, for 1 second on that? So before Congress did something in 2017 to try to address this, just historically leading up to that. So I'm a U.S. citizen. I have a bunch of even if we form a company, we put it in Ireland or somewhere and just keep the earnings parked over there. But then is it the same strategy we talked about earlier that I can get a bank to lend me money with that as the collateral? Yes. And then, then when I die, my shares in that foreign corporation pass to my heirs, and then the step-up basis, is that all happening here?
Yep. And I think in the corporate context, with a corporate shareholder. And that was the really big phenomenon, not so much individuals, but corporations. There's no step up in basis. They don't die and all the rest. But I think
I got you. The legal owner of the shares in the Irish-based company is itself a U.S. corporation.
U.S. parents, yeah.
I got you. Okay.
Let's say you're Microsoft or Alphabet or whatever it is. Those companies have terrific credits, and banks will lend the money. And in lending the money, the banks know that they own these very impressive businesses overseas with a lot of cash in them and so on. So you can borrow. The borrowing's not taxable. And a bank is perfectly happy to lend to you, knowing that in a pinch, you have to take the money back from Ireland. But there won't be a pinch, so you don't have to. So there were actually, it's estimated to be about $2.6 trillion of earnings owned by U.S. companies, but kept offshore. And that's a lot of money not getting taxed. And so part of the problem was the U.S. tax rate, 35%. It was so much higher than the rest of the world. So they fixed that. They brought it down to 21% in 2017. And at the same time, they said, but let's end this crazy...
Is that the capital gains or the corporate tax? What is that?
That's the corporate tax rate.
Okay. And that, just as an aside, that was like the second highest in the world or something, right? Yeah. Does that sound right to you? Like,
when we first started with 35%, it was middle of the pack. And the rest of the world cut their taxes on corporations. And we didn't for a long time. And it was, in my opinion, urgently needed. Did it. But as part of that, they also said, let's redesign the international tax system. And let's generally say that if companies earn income overseas, we're not going to tax it. We're just not going to tax it. It's not really part of our tax base. And then when they bring that earnings back, we won't tax it either. But this is a way that we won't discourage U.S. companies from doing business in the United States. So that was part of it. They did have a couple of minimum taxes. So it's not quite true to say we didn't tax this stuff at all, but it was at a low rate. And so what they wanted to do is they wanted to say, for anything going forward, we're not going to tax it when it comes back. But what do we do about the money that's accumulated? And it would be hard to say when you pay a dividend.
I'm sorry, Dave, can I stop you? Because I'm getting mixed up.
Yeah.
If the problem was, oh, wait, they're keeping their earnings parked overseas where we can't tax it, that seems weird. And that it sounded like you were saying, so the solution was to say, no, once you bring it back, we won't tax it either.
Right.
So how does that fix the problem of, like, doesn't that just mean now it's not, isn't that codifying that it's not taxed? Whereas before, at least there was a chance.
So that's exactly the point. So what they're saying is going forward, we're going to tax active income abroad at a very low rate, and in some cases, not at all.
Okay.
But the problem we're trying to fix, Congress said, is not only or even so much getting taxed on that money, it's more that we don't want to create this weird situation where U.S. companies won't bring capital back to America.
Okay.
So they were basically saying, forget about the 35% tax. There'll be a much lower tax. And then it doesn't matter whether you bring it back or not. There won't be an additional tax.
Okay.
So there was no longer this effect of discouraging the money from coming back.
Okay.
The problem was the minimum tax that I mentioned was only going to be applied starting then. So what about the $2.6 trillion sitting overseas that had never been taxed? In theory, you'd still want to tax it when it came back, but then it would get really complicated. You get a dividend. Did it come from the untaxed earnings or from the new earnings? What Congress decided to do is, let's just do a one-time low tax on all that earnings sitting offshore. And that way, whenever people bring money back, we don't have to tax it because we will have collected our smaller tax on that. Transition tax is the tax that's being challenged in the Moore case.
Okay.
The Moores are basically saying, while we owned the shares, our company earned money, and now you're taxing us as the owners on the money that the company earned. And that looks like a tax without a sale, which is a violation of the realization rule. And we think the Constitution says that you cannot impose a tax unless someone has a realization event like a sale. So that's the essence of the case, is the court is being asked to decide whether the tax on a corporation's earnings could be attributed to a shareholder, even though the shareholder hasn't sold.
Okay. What's the, Like how far along is that in the process, that particular case?
So the way the Supreme Court works, they have to decide whether to take a case. They decided to do that back in June. The taxpayers then have submitted a brief making their arguments. There are people called amicus curiae, who are also submitting their own arguments about why the taxpayer is right. And then yesterday, the government submitted its brief in response saying, no, they're wrong. This is all constitutional. It's all fine. And there are other amicus briefs coming in. I'm actually a co-author of one of them, and I think it is constitutional. We think it's okay. And the argument is scheduled for December 5th. So on December 5th, the lawyers from both sides are going to make their case to the court. The court will ask questions. And then sometime between December 5th and the very end of June, the court will issue its opinion on what it thinks about the issue.
I've heard the phrase amicus brief a lot. Can you tell us, what does that mean? I don't know what that means.
Sure.
Is it friend of the court? Is that what it stands for?
It means friend of the court. And the basic idea is when the Supreme Court, like a lot of times when a court decides a case, let's say, I sue you, Bob, and we're unhappy with each other. And some judge is going to decide which of us is right. And it matters a lot to each of us, but it's not that important to the rest of the country. Maybe there's a precedent that the judge will set, and then others will know the precedent, and so on. But when the Supreme Court does this, it's really not about telling the Moors whether they were right. It's about clarifying the law for the whole country. Mm-hmm. And so for that reason, a lot of people have an interest in encouraging the court to do one thing as opposed to another. And that's what these amicus briefs do, is they offer interested parties, people not in the case, but who would be affected by the case, the opportunity to make their own arguments.
Okay, so is it somewhat analogous? Like if the EPA or somebody is going to do some new regulation, right, they have a comment period and various parties are allowed to chime in?
Yes.
Is it sort of like, okay. Yes. Are you allowed to comment on what you think the merits are of the various positions?
Yeah, sure.
Okay,
absolutely.
Would you mind doing that? I mean, obviously you think your position is the right one, but...
Well, the big issue here is how broad the court will be in resolving the case. And my own view is that the court can be very narrow in deciding this case. When the taxpayers asked the court to take it, they described a much broader issue than I think is really there. The very broad issue they described is actually, Bob, the one we were talking about earlier. Can a shareholder be taxed on its unrealized capital gains? Is that constitutional? And on that issue, as you said, if you ask an economist, when my stock appreciates, do I have income? The answer is, of course, in the sense that income is just a measurement of your potential spending. But if you ask a lawyer, is there income? Well, then that's going to turn on what the tax law says. And under current law, in most situations, you do have to have a sale. But the fact that that's the law doesn't mean it has to be the law. And so the question is, does the Constitution say that in allowing income to be taxed, they meant realized income? So that's the big issue. But there is a narrower issue. And I actually think the court might decide on a much narrower ground. And that is that here, there actually is a realization. It's just that the corporation realized the income. So we're not talking about a tax without a realization. We're talking about a tax where the realization was by someone else. And can you tax the owner with the entity's realization? And I think the answer there is yes. And one way to think about it is, how do we tax partnerships in this country? I imagine many viewers have never focused on it, but the basic idea is that if Bob and David form a partnership and our partnership does some business, the partnership might sell something, and legally, it's the partnership that owned it and sold it. But what the U.S. tax system does is it doesn't tax the partnership, it taxes Bob and David, it taxes the partners. So there is an important part of the economy where it's accepted, and the Supreme Court has said, with a partnership, you tax the partners. It's fine. And then the question is the same rule applicable for a corporation? because the Moores aren't partners, they're shareholders in a corporation, is there's something different about a corporation. And the reason the taxpayers say there is there was a case back in 1920 where the court suggested there might be a difference. But I think over the years, that language in that case, court has distanced itself from it, and it isn't really what the case was about. So the argument that I think is the way the court can resolve this pretty cleanly is to say, you know what? We don't have to decide whether the Constitution requires a sale or a realization, because that's not presented here. There was a sale or a realization here. It was just for the corporation, and we think it's fine for Congress to tax the owners of the corporation instead of the corporation.
Okay, great. Okay. And then I suppose the other side argument is just kind of spelling out the things we've talked about earlier.
Yeah. And in terms of the question, so because what I'm saying is that the big issue, they probably can just avoid it here. But if they were to take it on and ask the question, well, but let's say this was just the owner of a tech company and she hasn't sold her stock and Congress wants to tax her on it. Is that constitutional? Or it might address that here, or they might pick another case to address it. My own opinion is it is constitutional because the word income, Congress didn't use the word realized.
Right.
They just said income. And what does income mean? Well, I think when you do constitutional analysis, part of what's important is to try to figure out what the word meant in 1913. And what's interesting is that there had already been taxes imposed by the country at various points that did not require a sale. And so there were already income taxes, including one that had just been enacted a couple of years earlier, that taxed you without a sale. So when the word income was used, it seems reasonable to me that they were just referring to what already existed. But there's a counter argument based on other things that people were saying, doing in 1913. And so I think that's what the court is going to focus on.
Okay. And then, but even at those examples you have in mind, it wasn't a wealth tax. It was an income tax, but it was on the unrealized gains, in modern terminology. Okay.
And I do think, Bob, that to some people, it seems like the same point, but it really isn't the same point, which is why when the taxpayers urged the court to take the case, they even said, you need to draw the line here because otherwise what's going to happen is you're going to have wealth taxes and there will be no limit to what Congress can do. And I'll just say that for myself, I think wealth taxes are not constitutional. But at the same time, I don't think that's the same as taxing income that you're measuring just based on market value instead of based on a sale. So allowing, a tax on unrealized gains, in my opinion, does not mean that we also need to allow a wealth tax. They're different.
Right. Okay. And I do want to circle, maybe that's the last thing we'll do in the remaining time, is to come various proposals for things that are called wealth taxes that you're actually going to say, strictly speaking, no, that's not a wealth tax. But before we jump into that, just one thing to address, please, is I imagine is part of the issue that whether it's constitutional or just in practice, if you bought at a certain price and sold at a certain price, that's pretty cut and dry. Whereas if you're saying, I own a bunch of stock and it's certainly higher now than it was 10 years ago when I bought it, but its price changes second by second when the market's open. So every tax year, what price do we use to say what my gain was implicitly? And then if it goes down next year, does that mean I can offset my other taxes because I had a loss? Can you just comment on that stuff?
Absolutely. So look, when we step away from the Constitution and we say, sure, Congress can tax unrealized gains, but should they? The main reason why they usually don't is what you said. It requires valuation. You have to know what it was worth. It also means people have to come up with cash, which they'll have in a sale, but not they haven't sold. Now, the truth is, the concerns I just mentioned don't seem nearly as persuasive, or these issues aren't as problematic for publicly traded stock, because we do know what it's worth every minute of the trading day. And so you could then say, all right, if you have publicly traded stock, compare its value on January 1st with December 31st. If it's gone up, you have a taxable gain. If it's gone down, you have a deductible loss. And we could have that system. One of the challenges is that system would be, I think, close to impossible for privately owned businesses, for real estate, for lots of assets that don't have that kind of immediately accessible price. So then you say, okay, so we could have two rules. We could have one for what's publicly traded and another for what isn't. And the problem is, if the tax rate is the same, then the non-publicly traded stuff is better because you get the tax deferral. And then the system would be creating kind of a tax incentive to avoid publicly traded investments, which would be an unfortunate thing to do. So I think that's the reason why Congress is generally not taxed unrealized gains. But by the way, you could imagine adjustments. You could say, look, the tax rate will be lower for publicly traded property because you don't get the tax deferral. I mean, there are things one can do. But the reality is Congress does tax unrealized gains in specific cases, but mostly it doesn't.
Okay, great. So yeah, do you want to speak a bit on popular, like Elizabeth Warren and Bernie Sanders? They talk about a wealth tax. And I guess part of the context here is this is the stuff when people say, like Warren Buffett saying, my secretary pays a higher income tax rate than I do and stuff like that. It's because of some of these maneuvers. And there's way, like, given what you just talked about, if you owned or if you were the CEO or whatever of a big company, you pay yourself like $1 in salary and the rest is these other things just precisely for these reasons. Whereas a regular salaried employee doesn't have that kind of flexibility. So
yes, that's true. I will say the point is a bit overstated.
Okay.
And so it's interesting. There's a news organization called ProPublica that managed to get hold of the tax returns of the 25 wealthiest people in America. And by the way, whoever leaked them from the IRS violated the law. That stuff is supposed to be private, and the fact that it wasn't is problematic in a way. But if you look at that, there are two reactions you could have. The reaction that I had, frankly, was, this is a lot of tax. It's $1 billion of tax, that sort of thing. Another reaction is to say, but compared to what they have, the percentage is low. But when you get the kind of statement that Warren Buffett makes, it's true only if you imagine a tax law that's different from what we have. So if you imagine that unrealized gains are taxed, are supposed to be taxed, but they aren't, then all of a sudden the tax rate seems really low. Because Warren Buffett has this, $100 billion of untaxed gains. So whatever he pays as a percentage of that is very small. If his stock appreciates in a year and you say that should be income and we're not taxing it, the rate is low. But on the other hand, that's not the law. And so under the law, the effective tax rate it's a lot higher than the secretary's. But really, that's not the issue. The issue is, should we be taxing this unrealized gain? And it is an interesting question. There are arguments to do it. There are arguments not to do it. But here we have a possibility that the Supreme Court will require an answer, not based on policy, but based on a reading of the Constitution.
Okay, so partly with that is the context. Can you talk about some of the proposals recently, but people are like, oh, we got to make the tax code fair and make the rich pay their fair share, that sort of thing?
Yeah. So to me, it's interesting because if you are in the bottom half of the income distribution in America, you're not paying income tax at all. And the top 10%, they pay an enormous percentage of the income tax, 60, 70% of the whole thing. So I think there is a threshold question about whether things really are as unfair as people say. And I understand why people say that. It seems to me that a mark-to-market type approach is much more consistent with what we've generally done in this country than a wealth tax. Because the thing about a wealth tax is you're going to pay it every year. And even if your wealth has declined, you're going to pay it. Whereas with a mark-to-market income tax, it goes up, you pay tax, it goes down, they give you a deduction. So I think it is different. But
can I just stop just to make sure we're not losing somebody, Dave, even though you have explained the distinction. So the idea being, if I have assets right now that are worth 10 million and then they appreciate next year and rise to 11 million, but I haven't sold anything under the current code, I don't get taxed on that because I'm just still holding it. And you're saying you could see an argument for taxing that unrealized gain. So, I had $1 million gain and let's go ahead and tax that. But that would be different. You're not saying just because I have a bunch of assets, I should be taxed on my mere ownership of a bunch of property.
Yeah, that's well said. And let's build on your example. So we have someone who has $10 million of assets on January 1st. They grow to 11 million by December 31st. The mark-to-market tax would tax them on that million of gain, but not on the 10 million that they had at the start. Let's say the next year it goes from 11 million down to 9 million. You get a refund for you could deduct the 2 million of loss that you had that year. So with a mark-to-market tax, it's just tracking the changes. But let's contrast this with a wealth tax, the kind of thing Bernie Sanders, Elizabeth Warren, they've proposed. You start with 10 million and it goes to 9 million. Under the tax we just described, you'd have no income tax due. You'd actually have a deduction. Under the Warren-Sanders wealth tax, you'd be paying tax on $9 million. Next year, it goes down to 8. You're paying a wealth tax again around $8 million. With the mark-to-market tax, there's no tax, and actually you're getting a deduction. So the difference is whether they're taxing what you have, wealth tax, or taxing the changes in what you have, and that's an income tax.
Now, in fairness, at least if they're sensible, like the proposals for one versus the other, the rate on a wealth tax is going to be lower. Like, in other words, you could, in principle, say, design it so that it would be the same revenue under given assumptions.
Correct.
But then I know economically, like they affect, the incentives are a lot different. Like, I've just separately done work on that stuff, that it's, even if somebody with a given amount of wealth and what you think the thing would do under the current rules, and if you said, whether it's a wealth tax of a small percentage or an income tax that you would think would be the same dollar amount of revenue, because those different structures would have different incentives, people then would behave differently. And so in practice, it might not. I happen to think a wealth tax is very inefficient.
Right. But you're certainly right that if you assume a particular rate of return, they could look very similar. So if we assume that my wealth always grows by 10%, and then we tax my income at a 10% rate, 10% of or let's call it 20%, so the numbers are a bit easier.
Sure.
So I'm going to get, I'm going to pay a 20% tax on the 10% return. That's mathematically the same as a 2% tax on the investment. But it's the same only if my assumption about that 10% return is true.
Right.
And the assumption won't be true. And so the idea is the perfect equivalence breaks down, but there's still a rough equivalence. You're absolutely right.
I mean, among other things, it's just for the listeners, like, if you knew holding a stock now, it would be taxed even at 1% of its value every year, regardless of the change in price, that would affect its current market price. Like, people would take that into account, and it's so that anyway, it's kind of a weird issue. I guess though, for just circling back, the big picture. So it sounds like you're saying you think that the Supreme Court, if it wanted to, could rule somewhat narrowly on this, and it's not going to overturn the apple cart.
But they might.
Okay. And I mean, I've been shocked by some of the stuff they've done, like on social issue, regardless of one's views of what's right or wrong. I'm just surprised that they had such sweeping rulings lately. So suppose they did come out and say, no, that's unconstitutional, or like, what impact would that have? Would that change a lot of what's currently being done?
There are 3 things they might do. I mean, obviously they could just uphold the law, but assuming they didn't, there are 3 versions of this. One is to say, we, the court, think there's something uniquely problematic about this specific rule, and so we're going to strike it down. But as to other rules like it in the international tax area, and as to other rules like it more generally, we think those work. And interestingly, in the cert petition, the moment when the taxpayer was asking to litigate this case, the claim was that this was a very broad issue and it applied to a lot of things. But by the time the taxpayers wrote their brief for the court at a later stage, they've switched to say, actually, most things under the law are okay, just not this. And I have a feeling that tactically they're thinking the court would be more reluctant to do something that it thinks has sweeping implications. So they could just strike down this particular rule. That's still about a $300 billion issue for the US government, because there are a lot of multinationals that paid this tax that could then ask for a refund. But it's still limited in that way. The broader version is for the court to say, look, we're not comfortable with the idea of taxing shareholders on the corporate's gain in this international context and also in the domestic context. And that would strike down a bunch of rules. And that's more like $1 trillion issue. But then there's a third possibility, which is they could go much broader and say, don't tax people until they have the cash. And I'll just mention that that's a bigger deal. So sometimes we buy a bond and we pay $90 for it, and it grows to $100. And instead of waiting until the maturity of the bond for the $10, we have to pay tax on it. This is so-called original issue discount, or OID. And that's been the rule for many years, but it isn't consistent with the idea of only taxing people when they've sold. So in theory, the court could say that's not okay. Same deal with some, accrual accounting. There are businesses that pay tax based on what they're entitled to get, even if they haven't gotten the cash yet. Well, strictly speaking, that's not really consistent with this idea of a realization. If what the court says suggests that that's not okay, most of the business world in the United States follows that rule now. It could change. So we can speculate about how broad this is. I'm pretty sure in this decision, they won't go broad. But depending upon what they say, there could be more cases. And over time, more and more of the rules that we take for granted now could be changed. It's not what I predict, but in theory, it could happen.
Wow, yeah, that accrual accounting, I didn't even think of that. So it's strictly like a company does some work for a client, and then they have like accounts payable has gone up, accounts receivable from the corpus thing has gone up, and technically, a lot of the accounting would show that as net income for that period, and you pay your tax on that. But strictly speaking, the money didn't come in the door yet.
Right.
Okay. All
right. When really, Bob, I mentioned this because I think part of the reason the court is going to be careful not to say something imprecise and too broad is that enough of the briefs are pointing out this kind of issue that they're going to think, they might just think, well, actually, we think the tax is fine. But the other thing they might think is, no, we think this tax is not okay, but we want to be sure that it's not okay for reasons that are pretty limited and that don't apply to all this other stuff. And so my guess is we're going to get either this thing upheld or struck down in a fairly narrow theory.
Okay, and so that's part of the function of the amicus briefs is that, at least in theory, their staffers should all be reading that stuff and then letting them know, hey, we haven't thought of this. Like, make sure you keep this in mind when you're writing your decision or your opinion.
Because remember, the Supreme Court, they're not Congress. They don't have committees with tax experts in their staff. It's not what they're supposed to do. It's not what they do.
Right.
So therefore, it's helpful to them to try to give them details that are not in the case itself, but could be affected by the case.
Right. Okay, well, great. This has been a fascinating discussion. David, thank you for your time.
It's my pleasure. It's been a lot of fun.
So, folks, you've been listening to David Schizer. He's Dean Emeritus of Columbia Law School, among other hats that he wears. And thank you for tuning in, and we'll see you next time.
This concludes another episode of InFi, the Future of Finance, with Dr. Robert Murphy. The information provided is for educational purposes and does not constitute financial advice. Consult with qualified professionals before making any financial or investment decisions. For more information on the host and for previous episodes, visit InFi, thefutureoffinance.io. Thanks for listening.